Good afternoon, everyone. Welcome to the Sunshine Ordinance Task Force Complaint Committee meeting for Tuesday, March 8th, 2011, scheduled for 3:30 p.m. and beginning at 3:30 p.m. Can we have the roll, please?
Yes, Mr. Chair. Member Nee.
Here.
Nee present. Member Washburn.
Here.
Washburn present. Member Knebber.
Here.
Knebber present. Mr. Chair, we have a quorum.
Thank you. Can we have the first item, please?
Mr. Chair, there is an agenda change. I believe through an email. Item number 3 has been withdrawn.
Withdrawn.
Yes.
Okay, thank you very much.
The first item, Mr. Chair, is the approval of February 8, 2011 regular meeting minutes.
Have discussion?
Move to approve.
Second.
Moved and seconded. Is there any member of the public wishing to comment? Seeing none, can we have the roll, please?
On the motion, Member Nee.
Aye.
Nee, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Mr. Chair, there are 3 ayes. The motion passes.
Thank you very much. Can we have the next item, please?
Item 2 is determination of jurisdiction on complaint filed by Matt Smith against the District Attorney's Office for allegedly refusing to release files related to an investigation.
Thank you. Is the complainant here? Is the complainant here, Mr. Matt Smith? Your item is up. Yes.
Please approach the microphone.
Please
sir.
approach the microphone. First, the complainant will have 5 minutes to state the reasons why you believe the task force has jurisdictions. Please remember, this is only a jurisdictional meeting. We are here to find if this task force has jurisdiction over this complaint. The merits of the case, if we find jurisdictions, the merits of the case will be deliberated in the full task force. You have 5 minutes.
Okay, I didn't prepare a 5-minute talk.
Use the microphone, please.
Thank you. Issues that might speak to jurisdiction are probably ones that you already know about. I was looking over portions of the Sunshine Act that were added in 1999 following the Rivero decision, the lower court's Rivero decision that the DA's office cited in saying that there was no jurisdiction in this case, and in those sections, there's an urging of the encouragement to the district attorney and sheriff to share records with the press and with the public. In this particular instance, I hadn't read Rivero in its entirety, or even started to until I received a notice that contained the response from the district attorney. Shame on me. I probably should have known that when I filed my complaint in the first place. But what kind of impressed me about reading the decision was that none of the compelling reasons that the district attorney at that time cited for keeping records private were asserted or reasonably existent in this particular case. As I said in the letter to the task force, we published a letter to the editor from an assistant DA who said that he was the one that had guided the department in rejecting my public records request, saying that their motivation was to protect the identities of victims of priests or whomever might have been the subject of allegations that are in this file. I'm sure you're familiar with the thing that I'm asking for. I have no interest in revealing those identities. There's portions of our local Sunshine Ordinance that deal with confidential information like that. And what struck me about the letter is that the policy of the district attorney's office of sort of rejecting jurisdiction of our local sunshine ordinance is so blanket and so, well, I don't need to make a polemic, but arrogant in my mind, that this assistant DA seemed to not even have read the sunshine ordinance portions that say that in circumstances like this, it's appropriate to either censor or black out sensitive or private material. Another issue that might be relevant is, I mean, since they're simply saying that there's no jurisdiction because Rivera is so parallel, but I think that both the state Public Records Act and our own sunshine ordinance speak to the issue of public interest in weighing the interests of the district attorney's office to protect either an individual investigation or as it said, or as Arlo Smith said in Rivera, the ability of the office to carry out investigations in the event that some witness might fear that in some future time investigation might become public. Well, this issue that I'm trying to get at here is about whether or not the Catholic Church and potentially, given that the Archbishop of San Francisco is now the second most powerful man in the Catholic Church, the issue of whether there was condoning of criminal rape of children en masse by a powerful public entity that the IRS sees as a public benefit organization after a fashion because it's a religion, and that, so anyway, that point was just the weighing of interest. I don't see, they didn't cite a specific interest, and it felt to me in reading them not citing any interest other than a moot one given the wording of the local sunshine ordinance that weighs anywhere close to the interest in the public knowing the degree to which this powerful public interested institution was conspiring to
Okay,
commit crime.
thank you. Please wrap up.
That's all I need to say.
Thank you very much. Is there any party here to provide facts and evidence in support of the complainant? Seeing none, is the respondent present? You have 5 minutes.
Thank you. My name is Catherine Miller, and I'm from the District Attorney's Office. I'm here to respond briefly to the matter today, and particularly to the matter of jurisdiction. It is the position of our office, and I believe also the recommendation of the city attorney in this matter, that you find that you do not have jurisdiction over this matter. It is our position that our investigative and our prosecutorial functions are state functions, that they are subject to the California Public Records Act, but that those limited functions are not subject to the Sunshine Ordinance. And we do cite the case of Rivero because it is definitive to this situation. It has been upheld in other counties as well. And we believe that it is persuasive on this issue. We do not feel that it falls before the jurisdiction of this body, which is not to say that we don't understand the complex issues around whether to open up or not open up our files. But just as a jurisdictional matter, we don't feel that it does. And I'm happy to answer any questions.
Thank you. Is there anybody present to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Nee?
Question for Mr. Smith.
Yes.
Please.
Please approach the microphone.
Mr. Smith, in your letter, I guess it's directed to the task force. Yeah, in your letter to the task force, you cite a little statement by Jim Ewart, whom I know very well and whom I respect. He said, you quote him as saying that the confidentiality claim by the DA's office, he says it's flatly untrue. The DA's office, quote, can release them if they want to. Now, to me, that sounds like there's an option there, not necessarily a requirement. The other question I have, though, and either you or Ms. Miller or both of you could answer it. The district attorney cites section 25303. It says that particular section of the penal code prohibits the county board of supervisors from obstructing the investigative and prosecutorial function of the district attorney of a county. Now, that raises a question as to whether all of the files that you have requested deal with cases that are ongoing. Have any of those cases that you are interested in looking up here, have they been actually concluded? Do you know? Does Ms. Miller know?
My belief that they are all closed comes primarily from a letter to the editor by, let's get the name correct, an assistant district attorney by the name of Elliot Beckelman, saying, I could just hand you this letter to the editor for him, but saying the cases were long closed. Additionally, speaking with Terrence Hallinan, he had said they were closed. And when the cases got a lot of press because the issue of statute of limitations surrounding these cases was a big national issue. Because the state, if I maybe remember this slightly off, but the state legislature passed legislation opening up the statute of limitations briefly. That was not that was deemed unconstitutional. The statute of limitations went back into effect. So it seemed it was understood by Mr. Hallinan pretty solid that those cases couldn't be opened up again. And in the letter to the editor, the main assistant DA responsible for, according to himself in his letter, for refusing to release any of those records, saying that the cases were long closed.
Oh, so when you say closed, you mean concluded, right?
I think that's what I...
Concluded as opposed to closed off from the public.
Oh, correct.
Okay, thank you.
You had an earlier question about the meaning of a portion of my submission. You had two questions. No?
No, I think they've been answered. Thank you. Would you like to respond?
It's the position of our office, and again, this is also upheld by case law, that the principle of the investigative exemption applies to both completed and ongoing investigation and prosecution. So whether our investigation and prosecution efforts are completed or not, that we do not open up our files unless we determine that we're willing to, and that they're not governed by sunshine. And the reason for that, put most simply, is that witnesses, if they know that even after something is completed, that information can be made public, that it may have a chilling effect on investigation.
Thank you. Further discussion? Again, this is another case where I have some disagreements with our city attorney about the difference between discussing the merits of the case and jurisdiction. I am inclined to widely hold jurisdiction in any case that may fall under Sunshine Ordinance. And I understand our city attorney's position. I understand the district attorney's the district attorney's position too. I mean our assistant district attorney's position. But I still find that this is a case that would fall under jurisdiction. Now, the merits are a separate matter that I think should go before the full task force. But in this case, I would be kindly towards finding jurisdiction in this case.
I agree. I think that this is a matter for the full task force. It touches on a number of issues we've grappled with over the years, and I think it warrants a hearing before all of us.
Okay, thank you. At this point in our process, first the respondent and then the complainant can have 3 minutes to add any concluding or rebutting remarks. First, that would be the respondent. If you have anything further to add.
The only thing I would say at this point is that we would obviously ask for you to reconsider your position. We feel that based on the case law, multiple cases about this very issue, that the matter is fairly clear. Thank you.
Thank you. The complainant, you have 3 minutes.
I would just point out that the reason that was just given by the respondent for wishing to conceal these records, that's to say, compromising the integrity of investigations by releasing the records, to compromise the integrity of investigations by discouraging witnesses to come forth, is a different reason than cited by Mr. Beckelman, who claims to have been the assistant DA who advised that the records be kept secret, and his letter, which I'll rip off and give to you, goes into the reason being the desire to keep names of witnesses secret. This what this seems like to me is a claim of blanket lack of jurisdiction. We can make up any reason we want to. We don't even have to have a reason. Who cares about specific reasons that might have been brought up in the Rivero case? We are separate from the city. Our values are completely different. We don't abide by the law when it comes to making the public aware of what the government is doing. That's what I have to say.
Thank you very much. The matter is back to the task force for motion, deliberation.
Move to find jurisdiction.
I second the motion.
Okay, the motion is to find jurisdiction in this case. Do we have any public comment on the motion? Thank you, sir. You have 3 minutes.
Thomas Piccirillo. Yeah, I'm speaking in support of you finding jurisdiction. His request is seeking records going back 75 years. I'm a little troubled by that in terms of the expense that the district attorney will have to bear if you're going to give him 75 years of records. Nonetheless, clearly you do have jurisdiction, and the records reasonable records should be provided to Mr. Smith, with the victims' names being redacted. But again, I'm troubled by the request for 75 years of records. Thank you.
Thank you. Is there any further public comment? Seeing none, public comment is closed, and back to the task force for vote. Can we have the vote, please?
On the motion, Member Nee.
Aye.
Nee, aye. Member Washburn.
Aye.
Washburn, aye. Member Knepper.
Aye.
Knepper, aye. Mr. Chair, we have 3 ayes. The motion passes.
Thank you very much. And this will be on this month's?
On this month's calendar.
Okay, and what is the date of that specifically again?
That, I believe, is the 22nd.
Okay, this motion will be calendared for the February 22nd meeting of the full task force. Thank you. Can we have the next item, please?
Next item is the administrator's report. I have nothing else to add, Mr. Chair.
Is there any public comment on the administrator's report? Seeing none. Can we have the next item, please?
Next item is public comment for items not listed on the agenda.
Is there any public comment for items not listed on the agenda today? Thank you. You have 3 minutes.
I was on the agenda, 11004. So I'm not clear how you go to public comment without it 1004 being addressed.
We were informed that that was withdrawn.
Yeah.
So-
Well, I spoke to Ms. Tebow 2 hours ago, and she assured me that she is going to give me my entire file by the end of the week.
Okay.
So I'm grateful for the existence of the Sunshine Ordinance Task Force, because without your existence, I would have had to file a lawsuit to get my entire file. So for that, I'm thankful. But there's another issue in this case. I have dismissed my complaint, but this is an ongoing issue with HSA regarding confidentiality laws. So in that sense, I sort of regret dismissing my complaint, although I am going to get my entire file by the end of the week. So I think the task force needs to do one of two things. They either need to outreach HSA and advise them on confidentiality laws and how they don't apply to an individual who's seeking his own file. Or the next time this issue comes in front of you, you resolve it against HSA. Thank you.
Thank you very much. Is there any further public comment? Seeing none, can we have the next item, please?
The next item is announcements, comments, questions, and future agenda items from committee members.
Does anybody have announcements, comments? Seeing none, I would entertain a motion to adjourn.
I so move.
Second.
The rise and vote.